our society has come to a situation wherein the laws which were actually formulated for the betterment of the females are now being abused a lot. One example of such law is Section 498A of the Indian Penal Code. Section 498A comes into play when a wife is subjected to cruelty. जब कभी एक वाइफ को प्रताड़ना का सामना करना पड़ता है अपने इन-लॉज या फिर अपने हस्बैंड के द्वारा। क्रूअल्टी फिजिकल भी हो सकता है और मेंटल भी हो सकता है। What used to happen earlier in such circumstances is that as soon as the wife alleges before the police that she has been subject to pratarna by her husband or her in-laws, ऐसे सिचुएशन में पुलिस सीधे जाकर गिरफ्तार कर लिया करती थी हस्बैंड और इन-लॉज को। इन सारे सिचुएशंस इतने बार अब्यूज किए जा रहे थे जस्ट फॉर द सेक ऑफ रिवेंज और एज अ रिजल्ट ऑफ मेयर फैमिली डिस्प्यूट ऑफ पेटी नेचर। ऐसे केसेस में ना कि केवल परिवार बर्बाद हो रहा था, बट ऐसा प्रोविजन जिसको एज अ शील्ड प्रोवाइड किया गया था वाइफ्स को, वो एज अ स्वॉर्ड यूज किया जा रहा था अपने हस्बैंड या फिर अपने इन-लॉज को अटैक करने के लिए। इन सब चीजों को मद्देनजर रखते हुए सुप्रीम कोर्ट ऑफ इंडिया in the year 2014 in the judgment named Arnesh Kumar versus State of Bihar laid down certain guidelines after which the process of arrest decreased a lot. But this doesn't mean that whenever a complaint regarding section 498A is made by the wife, husband या फिर वाइफ के इन-लॉज को गिरफ्तार नहीं किया जा सकता। गिरफ्तार किया जा सकता है। प्रोसेस एस्टैब्लिश हो गया है। Whenever the police wants to arrest for the sake of investigation, the police needs to provide reasons for doing so. Without reason अरेस्ट नहीं किया जा सकता है। बट एक सवाल हमारे मन में जरूर आता है, क्या हमें ऐसे सिचुएशन में एंटिसिपेटरी बेल लेना चाहिए? Well, the discretion whether the police would want to arrest or not is totally upon the police. If the police feels that for an effective investigation, the police needs to have the husband and or the relatives of the husband in the custody, in such circumstances the police may take the husband and the in-laws into their custody. Whether the allegations are fake or they are genuine, वो तो एक अलग मुद्दा है जो कि कोर्ट में when it will be discussed upon the merits of the matter, it will be decided. But it is always better to avoid being arrested because it is very sharmanak before the society if in a family a number of police comes and takes away the husband or the in-laws of the wife. To avoid such circumstances, it is highly recommended for anyone who is made an accused in such types of matters to apply for the anticipatory bail as soon as possible. Nowadays, the police doesn't readily come and arrest the accused, but there are high chances of arrest if the wife who has made the allegation against the husband or the in-laws is of an influential nature, or who has either bribed the police or has some kind of political or connection related to the police, wherein she can put influence or she can create a pressure upon the police to act in detriment to her husband and her in-laws. Not only the police But the court has also become very cautious regarding the allegations of Section 498A against the husband and the in-laws. Therefore, the husband or the in-laws might not be arrested as soon as the FIR is lodged against them regarding Section 498A. But it is highly recommended that as soon as they get to know about the registration of FIR against them, they go to a lawyer and file an anticipatory bail so that police doesn't take any coercive step against them or arrest them. Once the anticipatory bail is filed and granted by the court, the husband and in-laws can be protected from being arrested, and whether the allegations made by the wife is true or not, those things will be discussed while the matter is being tried by the court.